penalty attorneys. We represent clients in the most progressive of states. I go to death row in Alabama and Georgia. Megan is Texas, Mississippi, and Louisiana. The prosecutors call our clients animals, abominations, the definition of evil. We call our clients by their names. We call them people, at times tragic and very damaged people. And we tell their stories because by telling their stories, we can defeat death. Megan is going to read from our essay about the stories that we tell.
Because these are the stories that can save our clients' lives, we must search and dig and probe for them. Where the rest of the world has looked away for years and years out of embarrassment or utter lack of interest, we seek out and embrace these horrors that our clients have endured, often at an age when they could barely speak. No one wants to admit that he tried to hang himself at age 14 but broke the shower curtain rod, leading to the worst beating from mom yet. No one wants to talk about how he prostituted himself after 3 days of sleeping in a car without food. If our clients have come to understand one thing, it is that they'd better hide these stories of weakness if they are to survive. And for some of our clients, that might be one of the few things at which they've ever succeeded. And yet somehow, in some way, we have to breach those walls, whether invited in or by wrecking ball. And once inside, we will resurrect memories and suffering that no one ever wanted to think about again. As lawyers who are drawn to capital defense out of a sense of compassion for the most damaged among us, the irony of this reality is difficult to swallow. Already our consciences are heavy for so many reasons. The double-edged nature of our successes, and most often saving a client from the death chamber means that he'll vanish into prison for the rest of his life. The permanency of our failures, the constant gnawing guilt that maybe we could have done more. But for us, it's the pain that we inflict almost every day that is our deepest wound. If we want our clients to live, we will inevitably end up hurting them, their families, and ourselves in the process. People gravely ask how defense attorneys can represent someone who committed a horrible act. But what would they say if they knew that as capital attorneys, we deliberately follow a course of action that causes a whole new kind of pain? From our perspective, the death penalty's greatest achievement is the hurt that it has caused and will continue to cause. Absolutely nothing about the death penalty doesn't hurt, and we, as compassionate people serving as capital defenders, feel at the same time like a sponge, a conduit, and a source of the death penalty's far-reaching devastation. A fair question then may be, why in the world would we keep doing it? For the many moments of grief, doubt, anger, and despair, there are also moments of joy. Walking a client not only off death row, but out of prison. A jury against the odds, rejecting a death sentence. Winning the right to a new trial based on evidence long suppressed by a prosecutor. Telling a client braced for a frightening death that he is going to live. But these moments are fleeting, and they are the exception. Then there are the moments that take place where no one else can see. We hear clients move from the depths of self-hatred to a realization that they're more than their worst moment. We witness the gift of forgiveness from all imaginable angles and sources. We watch a man once completely estranged from his family hold his grandchild. We sit with young people as they mature and accept responsibility for their actions. We see love flowing from the most unexpected places. These precious moments do not outweigh the hurt, but they soothe it. Still, the reality is that often we are left feeling wounded and angry. If we relied on regular victories to rejuvenate us, we simply would not last. No, we know all about the hypocrisy, racism, and politics of the death penalty, but none of that explains why we must do this work or how we will keep doing it. It's truly our clients' stories that keep us going. As much as they wound us, they also sustain us. They open doors to understanding not only our clients' humanities, but our own. Why do we hurt? Why do we love? Why do we do the things that we do to others and to ourselves? How do we recover? How do we forgive? How do any of us move forward? We find the fragility and resilience in our clients, and in the process discover the same in ourselves. That is not only why we do what we do, but why we love it so much. We learn more and more that life is messy. We learn to see gray where others see black and white. Through our clients' stories, we ourselves become more human, and we are forever grateful for that.
So hidden in the question, how can you represent these people, I think is the question, why do you do it? And the older I get, the more complex the answer to that question actually is. It's possible that I became a public defender because I fell in love with my criminal defense clinical professor in law school. I wanted to be as passionate, smart, and courageous as he was. I wanted to make a difference in people's lives as he did. He was a quirky, brilliant, and deeply committed defender. He was kind of a pretrial motions genius. No issue was too small to be scrutinized, developed, and creatively litigated. He was completely immersed in the work. He breathed, ate it, and literally slept on it. His platform bed was built above a filing system of case law, transcripts, and motions. He taught me that every case matters, and more importantly, that there is a client in every case. Or maybe I was already a defender in my heart and I was simply drawn to a kindred spirit. After all, I was always very wary of power and authority. As an elementary school child, my school reports warned that, quote, I always needed improvement in showing respect to teachers. Not only have I always been skeptical of authority, I have a visceral hatred of inequality. I can't really explain where this comes from, but it's always been with me. So much so, and it's so much a part of who I am, that if my favorite New York football team is winning by just too much, I reflexively switch sides and start rooting for the losing team. Growing up on New York's Lower East Side in the 1960s, I was a rebellious child brimming with the energy and strong convictions. My heroes were Gloria Steinem, Golda Meir, and other feminist giants that I watched as they bellowed into megaphones in front of the New York Public Library or leading braless women through Tompkins Square Park. I admired how outspoken, tough, and fearless these women were in their pursuit of justice and equality. Unlike the adult women that I knew in my middle-class apartment complex at Peter Cooper Village or my teachers at the local public schools, these women seemed free. They were unencumbered by the economic, political, and social barriers that existed for women and dedicated to envisioning a different world, far from the kitchens and stoops where my mother and her friends chain-smoked cigarettes, drank bottomless cups of coffee, and whispered about their husbands' infidelities and abuses. These feminist activists inspired me to believe that my life could be different and I could make a difference. So maybe I was born to be a public defender. Then again, maybe it was all about my father. A complicated and charismatic man, my father was the product of an upwardly mobile Jewish parents. The success of the family's garment business catapulted them from the Lower East Side to the Bronx, and eventually to buying a house on Long Island, the ultimate symbol of Jewish assimilation in mid-20th century New York. My father did not follow his parents' path. Instead, he used his charm and good looks to seduce a pretty, smart Catholic schoolgirl from Allentown, Pennsylvania, persuading her to convert to Judaism, marry him, and move to New York City and have 2 kids. At first, love blinded my mother to the fact that my father was addicted to everything: coffee, cigarettes, gambling, risk, alcohol, and drugs. His addictions defined our family life. He became hopelessly dependent on cocaine, Quaaludes, and later heroin. He was in and out of jail. He left us, disappearing for long periods of time, drifting in and out of our lives. Today, he would probably be diagnosed as bipolar and given medication to manage his intense, harrowing mood swings. Back then, he was just my mother's heartbreak, a disappointment, and a bad guy. Children love what they get, and so it was for me. I couldn't deny that my father was damaged, but I refused to write him off. To my mind, his struggles meant that we needed to do more for him. We needed to try harder. If we did, then somehow, someday, he might change. I didn't believe in bad people back then, and I still don't. Years later, he died of an overdose. He was 49. In some ways, I've never stopped fighting for my father, and I see glimmers of him in every client. Am I a public defender because I had a drug-addicted father? Was I drawn to the work because I grew up idolizing radical feminists, questioning authority, and always rooting for the underdog? Or was it that sexy law school professor? Any of these could explain my path, and probably all of them do. There are thousands of reasons to be drawn to the work that defenders do, but at the end of the day, the question may be simply beside the point. Whether it was love or politics or a potent combination, when I fell in love with public defense, I fell hard.
The book may have been mistitled. It says, how can you represent those people? The essays really are about why you represent those people. Now, if you want to know why I was representing Terry Nichols in the Oklahoma City bombing case, having been appointed by the court, you can read the essay. But I thought that I would take the title of the book seriously and share with you a couple of things that I said during the course of that representation, because our first job was to try to get the trial moved out of Oklahoma City. And this is what I said to Judge Mage in arguing the motion for change of venue. Governor Keating has been quoted over and over again, repeating his mantra, we will give these people a fair trial. Oklahomans are independent. We want to make sure we've got the right people, but if we do, they should be executed. As though the Furman versus Georgia gene had dropped out of his legal chromosome makeup. C.S. Lewis writes in one of his letters in a wonderful collection that there are times, as for example on a dark mountain road at night, when we would give far more for a glimpse of the few feet ahead than for a vision of some far horizon. The few feet ahead that we can see tell us that in this time and place that a jury in this city charged with that decision would be one as to which one can confidently say that there is the reasonable likelihood of prejudice. Two roads diverge before us, gathered as we are, with the decades of constitutional liberty piled so high and the anguish of the victims close at hand. To one of these roads we're beckoned from sadness to anger to vengeance. Governor Keating beckons us along that road by what I suggest is a deliberate design. The media have beckoned us along that road simply by their desire to serve their market. The other road I suggest to the court is the one the framers laid out for us, while the memory of unfair trials in distant lands was fresh in their minds. We neither dishonor nor deny the grief and anger of the victims, nor even their cry for vengeance. Your Honor, in this my 30th year in the law, I believe more than ever that when we summon someone, anyone, Terry Nichols, into court to find out whether he's going to live or die, that it is our job to construct where we best can a kind of sanctuary in the jungle. Now, in closing argument in the penalty phase, because we did get to one, let me share just a few words. We'd had 54 witnesses sharing their anger, their loss, their grief, and the government then using that as a basis to argue for the penalty of death. And I said in summation, I feel now when I think about that evidence as though I'm standing before you and trying to sweep back a tide of anger and grief and vengeance. And I'm given pause by the fact that I feel that way. And I wonder if sometimes you might feel that way. But when I think that, then I think of the instructions that the judge is going to give you. Because those instructions, as we contemplate this tide of anger and grief and vengeance, can get us all to higher ground. I didn't know then that was a song that Irish Dement used to sing. Because the instructions will tell you that neither anger nor grief nor vengeance can ever be a part of a decision reached in a case of this kind. I am, when I say this, not attacking these victims. We know their sacrifice, but we know that with the centuries of our civilization piled so high that we have come a long way from justice based on vengeance and blood feuds. This trial was moved from Oklahoma City because I submit to you it was thought that even the neighbors of those who lost so much would not do to sit in judgment. And to them, therefore, we can only say, when we hear their grief and their anger and their desire for vengeance, bless those in need of healing. And then towards the end, I suggest to you that the government wants to drag you back to a time of vengeance. I suggest to you that the FBI agent who said to Lana Padilla on the 21st of April, 1995, before a jot of evidence was in his hand, "Those two guys are going to fry," symbolized a rush to judgment that is at war with the conscience of the community and what it ought to do and ought to think about. I submit to you that to surrender your deliberations to vengeance is to turn your back on lessons that we have all learned with great difficulty and a great deal of pain.
Prosecutors are rarely asked, how can you prosecute those people? When I was a prosecutor, the people who usually asked were African American. I wouldn't call it the cocktail party question because they weren't the cocktail party type. They were poor people whose sons and grandbabies had gotten caught up in the system. It was usually more of a look than a form of words, and this is what the look seemed to signify. Now, it was the first time that a professional black man had ever paid much attention to their kid, and it was only because that professional black man, me, was trying to get the kid locked up. I became a prosecutor because of my experiences as an African-American man. The times I wasn't being harassed by police and security guards, I was being harassed by other young black men. Stopped and questioned by the former, robbed of my lunch money by the latter. Young black men are the most frequent victims of crime and also the most likely to be charged. I could have responded the way that a lot of my brothers do by not trusting anybody. You walk through the hood and you glare at the dope boys in the corner who make your community feel unsafe. Then when the squad car slowly rolls by and the cop takes a good look at you, you glare at them too. But I was an idealist, and being a prosecutor seemed to be the perfect solution to the concerns that blacks have about public safety and about civil rights. In the segregated neighborhood in Chicago where I grew up, blacks made the same claims about law enforcement that they do now. The times my neighbors were complaining about how the police, times my neighbors weren't complaining about how the police treated them, they were complaining that the police were never there when they needed them. Being a prosecutor seemed to be the perfect solution. It didn't work because my tool, locking people up, was too blunt an instrument. In our adversarial system, you have to choose sides, and the side that prosecutors choose mean they end up selectively applying criminal laws. They defend the police when they do stuff like stop and frisk, and they lock up a lot of black people. When African American prosecutors talk among themselves and they say, I wouldn't trust this guy in a dark alley, they could be talking about the police as easily as their most recent defendant. And people ask if when I was a prosecutor and I got stopped by the police, I told them what I did for a living. Yes, sometimes. But it didn't always make a difference. It didn't make a difference the time I told the cop that I was a prosecutor, and he smirked. And he said, so you probably know this already. And he read me my Miranda warnings.
Hi, isn't this a great book? I feel lucky to be part of it. I like guilty people. I do. I can't help myself. I prefer people who are flawed and complicated and do bad things to those who are irreproachable and uncomplicated and do the right thing. Flawed people are more interesting. Take, for example, a recent client I'll call Renee Cooper. Ms. Cooper was African American in her mid-50s, obese, toothless, and always fretting about something: how she would get to court, how she would get to the mental health clinic, the long lines at drug testing, various family problems. Ms. Cooper had been in and out of trouble much of her life. She had a long sheet, consisting mostly of petty offenses like drug possession and prostitution, but she had also done time for selling drugs. She was doing well on parole when she caught a new prostitution charge. The facts of the case were memorable and not in dispute. Ms. Cooper had offered to perform oral sex on an undercover police officer in exchange for fried chicken. Ms. Cooper was only slightly humiliated to have been arrested under these circumstances. As far as she was concerned, she was hungry, and a blowjob in exchange for dinner was not a bad trade. But the arrest was a problem. It was a violation of her parole and meant she had to go to court on the new charge. We tried hard to get her to complete a mental health diversionary program, a therapeutic treatment-oriented alternative to criminal prosecution, so that Ms. Cooper might avoid a new conviction and parole violation. But she missed meetings, tested positive for drugs, or waterloaded before testing, and otherwise failed to comply with the requirements of diversion. So the mental health judge put her back on the regular criminal calendar. This was not a triable case, and Ms. Cooper knew it. Her plan was to plead guilty and throw herself on the mercy of the court. She didn't want to go to jail. By some miracle, her parole officer took pity on her and did not violate her for the new crime. So the only thing we had to worry about was whether the judge before whom Ms. Cooper was scheduled to appear would send her to jail for doing something as desperate as offering a blowjob for fried chicken, assuming she was going to continue to test dirty or otherwise fall short on pretrial release. I got a kick out of Ms. Cooper. She always greeted me with a big bear hug. She called me Miss Abby. She was funny and charming. She said she had heard of me, that I was known as a great lawyer. I doubted this. Let me try to explain what I mean when I say I like guilty people. I don't mean to be glib. Of course, there are crimes so cruel and depraved they turn my stomach. I think of child abduction, captivity, rape cases, certain hate crime, and cases featuring gratuitous meanness and violence. It is hard not to feel for the victims. It is hard not to feel revulsion toward the perpetrators. When I say I like guilty people, I mean the vast majority of my clients who have committed crimes for a variety of reasons, but who are not evil. This may be what every defender says. My clients aren't wicked, but damaged, deprived, or in distress. The reasons for their criminal conduct are both complex and simple: growing up in abusive or neglectful homes, falling prey to drugs or alcohol or gangs, being young and impetuous and lacking in judgment and resources, having cognitive or mental health problems, losing control in a moment of rage, making bad choices in a bad moment. For the most part, my clients feel remorseful and ashamed, at least by the time they get to sentencing. Still, I don't want to duck the question. I'm often asked about what sorts of clients or cases I could not defend. It's a fair question, a subset of the familiar cocktail party question: how can you represent those people? Although I have never turned down a court appointment based on the nature of the case, some cases are harder than others, and some I wouldn't be eager to undertake. But I think I could find a way to zealously defend pretty much anyone. The only category of criminal defendants I won't represent is police officers accused of brutality or corruption. This is purely out of loyalty to my client base. I prefer to leave these clients to others. Ms. Cooper, the woman accused of prostitution, was ultimately placed on probation, notwithstanding her less than perfect performance on pretrial release. The judge said the important thing was she had no new arrests. I think I wasn't the only one charmed by Ms. Cooper.
So I did not write a portion of this book, so I'm just going to tell you what I say when I'm asked this question at a dinner party. And I think the question that I like even more than how can you represent those people is when people look at me and they say, now, do you ever have a case where, like, you know somebody's guilty? And I laugh to myself thinking, it's pretty much every case, and if I didn't do that, then I would have to find another profession. And the other thing that makes me laugh at a dinner party when I start to talk to people about what I do, we've had a couple of cases that have been in the media, and people will start talking about the case, and someone will say, oh yeah, she's involved in that case involving, that guy that dressed up like a phony firefighter, or that terrorism case, and we'll be talking for a few minutes, and then someone will say, wait a second, you're defending that guy? We've been talking for 15 minutes already, and it just dawns on them, and then they look at me saying, you don't look like a criminal defense attorney. I'm not really sure what we're supposed to look like. But so, when I'm asked that question, I know in Monroe's book it says, the lawyer tries not to seem bored or peeved while offering a range of replies. I never look bored and peeved when I am asked this question. I love this question because it gives me, as the enlightened one, the opportunity to enlighten the people that are less fortunate to know that this is the right thing to do. So, I think when I'm asked that question, I immediately say to the person, it doesn't matter at all when you're representing an individual, whether or not that person is actually guilty. That really doesn't factor into your representation of somebody at all. And the reason for that is because in this wonderful country that we live in, we have protections where the prosecutor actually has to prove your guilt beyond a reasonable doubt in order for you to be convicted and go to prison. That is a wonderful thing that we are afforded, because that, not only does that apply to the guilty, but it applies to the innocent. And so that fundamental principle is what keeps all of us safe from wrongful conviction. And for me, wrongful conviction, that term wrongful conviction, is really what this is all about. What we do day in and day out, representing both the guilty and the innocent, is what protects all of us from being wrongfully convicted. And what does being wrongfully convicted mean? Well, I don't know if you can really feel what that is until you've walked into a prison and you've met with an innocent person who's been sitting in a prison cell, someone who's being told every day when they can eat, when they can sleep, how they have to walk down a corridor, what they have to wear, when they can go to the bathroom, where they can go to the bathroom, when they can see a loved one or speak to a loved one, and when and under what circumstances are they allowed to actually touch their loved one. When you think about guilty people in prison and being robbed of these basic fundamental rights that we have, so what? Everybody thinks, so what? They deserved it. They had it coming to them. But what about the innocent people? Because there are a lot of innocent people in our prisons today that are experiencing that hell on earth. And that's why all of us really privileged people, do what we do every day. And so the next time all of you are at a dinner party and you overhear somebody saying to one of us privileged few, well, how can you represent these people? I hope that you remember all of these stories, because we are really the lucky ones, because we're the ones who have chosen to protect every one of you from that extremely unfortunate fate. Thank you.
I'm Robert Gottlieb, and I am a criminal defense attorney. It is a political decision. It reflects a political value. And when I use the word political, I'm not talking about Democrat. I'm not talking about Republican. I'm certainly not talking about the Ted Cruz type of political. I'm talking about values. I'm talking about a reflection of what I believe personally is of value. The value of the individual, the value of human rights. It's a constant value. I am a criminal defense attorney. It's a value that was reflected by our founders who fought to limit government, to prevent government from taking any one of us, charging us, taking away our liberties and even our life. It is a value that prevents government from interfering with the individual. I live in the city, and before summation, in a trial not long ago, the night before the summation, I walked over the Brooklyn Bridge, and it was 11 o'clock at night, and as you look over to your right as you're heading over to Brooklyn, you see the Statue of Liberty. It's a value. And when I saw that Statue of Liberty, I changed my entire summation because it then became clear. Being a criminal defense attorney and fighting for the individual, guilty or innocent, reflects the ideal and protects the ideal. And thousands of people have died for that ideal. So we were asked to represent Adis Meduzhanin, who was charged with the plot bombing the New York City subways as a member and in affiliation with Al-Qaeda. And I can tell you about that because I firmly believe in those values, and I have had that question asked of me so many times, how do you represent these people? That was the test for me and for my firm, to represent the person who had gone abroad, trained with Al-Qaeda, planned on coming back to place bombs, as the dean mentioned, a few feet from our office. And even within our law firm, there was division. In fact, we lost an associate who did not want to participate in a trial such as that. But I'll tell you something about that trial, because we took it, and we took it because we too felt, how do we not take that case? And in taking that case, I saw what could happen when the government abuses its power. I received top security clearance in order to represent the alleged terrorist. In order to obtain certain discovery, you get notified by your handler in Washington that there is confidential, secret information that is to be reviewed by us by way of the discovery process. So I went into the secured room in the courthouse. I opened the drawer using the secret passcode, not knowing what was going to be in the cabinet. And in the cabinet was a CD. I had no idea what was on the CD. There's a secured computer in this secret secured room. I put in the CD. The first sound on the CD was a call by my client to my law firm. You heard my client. You heard my secretary. My client asked to speak to me. She said he will return the call. I continued to listen, and the second call was Robert Gottlieb calling my client. And I listened to the entire conversation. And then that conversation ended, and I listened to a second conversation between me and my client, and then a third, and then a fourth, and then a fifth. 43 intercepted conversations between the client and the attorney. The FISA court. That's what we have in this country now. This secret court that approved the interception of attorney-client conversations. No minimization, government listening, no notification until the eve of trial that I was recorded. And when we went to court and we asked the judge for all the supporting documentation that would have justified the government intercepting and abusing one of the most sacred concepts and principles of our system, we wanted the supporting affidavits. We were told they are secret. I'm a criminal defense attorney, and I do it because I love the Constitution. And I know, we all know, that the government is more than capable and willing to violate that Constitution in the name of security. And when that is done, we are all in danger.
That was just terrific. What more can you say? Great. So what we're going to do now is to turn allows people in the audience to ask questions, either general questions to anyone or questions to particular participants. We have a mic somewhere, which has now disappeared, but we can take one of the mics off the table. Oh, there's a mic. So why doesn't anyone that wants, and over here we can take one of these mics. Does anyone want to ask any questions here? Nobody wants to ask questions? I know there's some, oh, where's the hand? We can hear you from there, you can do it. Try it out.
This is just a general question. A big theme that seemed to come up was the issue of the war on drugs and its failures and its incredibly high cost. Do any of you see or hope to see or imagine a stop to that war anytime soon, or how that would even begin to go about?
Just repeat it again, because I was paying attention to the technology.
Jerry Springer. The question was concerning the war on drugs. It was a theme that seemed to come up an awful lot and comes up a lot in the context of criminal defense. And do any of you feel there's a way out of the war on drugs? Is there a way forward with it? Is it just an intractable part of our culture at this point? Is there any way to stop what seems to be agreed on by many prosecutors as well as being an unworkable situation?
So I'd like to believe that we became more thoughtful, compassionate, enlightened people. I suspect it has to do with the fact that crime is down so low that people feel safe and they're not reacting in reactionary, unthoughtful, draconian ways any longer. So the conversation seems to be, more enlightened. There seems to be a lot of narrative. And if anything, I think that shows that things are shifting. You look at New York City and it's stop and frisk. Talk about something that has been rumbling under the surface for a very long time, where finally, policy and community organizing and the legal profession and the politicians all joined together and basically stopped something that was really brutalizing and stigmatizing, 700,000 Black and Latino young men in the city of New York every year. So I think you're seeing that rolling back. I think you'll see a new police commissioner, and I think in large measure that's because conversations about the war on drugs and what the devastating consequences have been to entire communities, to say nothing about how expensive it's been to our country, both morally and economically. And so, yeah, I think that you will see that beginning to roll back. I think you heard that in Attorney General's speech to the ABA. I think you're beginning to hear a new narrative, a different narrative, and nothing is so intractable that you can't change it if you're committed to it, so work at it.
Anybody else have any questions?
Oh, sure, yeah. I agree with Robin that we're definitely ratcheting down the war on drugs now. I think in part because it's led to so much incarceration, especially in the African American community. I think we're more concerned about the cost of that incarceration with regard to both money. In New York, you guys have what's called $1 million blocks, city blocks in the Bronx and Harlem, where if you just look at the cost of locking up people on that one block, it's $1 million. And a lot of people are asking, well, what if? Well, what if we spent that money on education, on healthcare, on jobs training? What a difference that might make. New York is also an inspiring story, though, because you all have ratcheted down your laws, the Rockefeller drug laws, made things a lot more fair, not nearly where they should be, but more fair than they were. And guess what? Crime went down. You locked up fewer people, and crime went down. So that's an inspiring story. I'm also very concerned, though, about the racial justice aspect of the war on drugs. Good news for the majority of you here who are both white and have used marijuana. That's pretty much legal. It's pretty much legal to be a white person and use marijuana. You're not going to get caught. About 80% of the people who are arrested for marijuana crimes in New York are African American and Latino. And so there is a racial justice aspect to this that I think is important for us to care about.
Anybody else have any questions? Okay, Janelle?
Here's the man.
Wait, we'll give you a
Yeah, sure.
mic.
I just thought of this after you said that, but although the judge shrouded the FISA order in secrecy, was there a way that you could report either the FISA judge or those who requested it to the state bar for violating ethics confidentiality? Is there an ethics issue you can raise?
The answer is no. There is no ethics issue because Congress has approved the FISA court. The judges appointed to the FISA court are appointed at the very highest level. The only way to fight it is to get Congress to do what the Constitution requires them to do, which is to end it, to withdraw that legislation. There is simply no place for a FISA court in this country, but it's not an ethics issue.
The follow-up to that is each state has their own bar, and to be admitted to that state, is that not a state issue? And if Congress's FISA act, does that automatically preempt the state bar's ethical guidelines or rules?
Yeah, I would certainly defer to Monroe as to whether or not there's a state ethics issue that somehow is usurped by the FISA legislation.
It's not an ethics issue. Is it on? Yeah. I have written a short essay titled "Our Inalienable Rights Are Lost Forever." There is nothing that can be done. Ironically, members of Congress have said that the National Security Agency and a dozen other agencies have violated the rules that we have laid down to limit their abuses. So what we have to do is pass more rules to limit those abuses. They ignore them, they lie, they blackmail, they arrest, they prosecute, they torture. There is no way that we are going to, I mean this quite seriously and very sadly, there is no way that we can, at this point, end the surveillance state.
Norm?
I was deeply moved by all of the remarks, and I think implicit in them was a common theme, which is the culture that is excessively vengeant and that overly confines people, regardless of whether they're guilty or not. And I would just invite anyone to talk about that more explicitly.
Mike, he wants someone to comment, or all of you, or any number of you to comment on a culture which seems to incentivize over imprisonment and the imprisonment of innocent people.
Well,
Is that right?
we begin with the fact that the United States incarcerates 5 to 7 times as many people as a percentage of population as any comparable country. And with the fact that until the Supreme Court began to do something about it, we had more than 2,500 people serving LWOP for crimes committed before they were 18. That's 2,500. Israel was second, they had 7. Pardon?
LWOP, life without parole.
Yes, LWOP, life without parole. Okay, fine. Thank you very much. Sorry for the... Now, so the answer is that at the level of social policy, over-incarceration, racial bias in sentencing, and all the rest of it seems in some way to be acceptable. Subject now to some pushback, General Holder's partial and somewhat hypocritical pushback, plus concerns about the costs, the physical, to the taxpayers of over-incarceration. But ultimately, the people sitting around this table seem to be doing the only thing that has any long-term and lasting effect, because criminal trials are didactic. That is to say, they are occasions when the public gets to observe something happening. And these didactic criminal trials, if conducted fairly, with a fair result, do 2 things. First, 12 jurors in the box are reachable. Not in a short trial. It takes about 3 days to get them to where you can talk to them about stuff, and spare somebody's life or really believe in the concept of reasonable doubt. And that's assuming that you've had good voir dire, which you don't. But the next thing that begins to happen is that people see these trials. In North Carolina, the device of making sure that death penalty cases had proper representation has resulted in a 2/3 reduction in the number of death verdicts. Why? Because the public realizes that, oh, he didn't get the death penalty. That's not so scary. We read about that in the paper. I guess there were some reasons. And second, prosecutors understand that as soon as you start to level the playing field, then they're not going to overcharge quite so readily. So, that's faute de mieux, that's what we're up to. Is it going to make a great change? Well, I don't know, but it's the only thing we know how to do.
One other quick comment about that culture. I think 20 years ago, we abandoned the cultural discourse and debate in this country. We let the other side frame the narrative. We let them talk about people in the abstract. They were called criminals. I think what we've done, and this is why we're here today, okay? Every story that you heard today wasn't about defendants. Okay? It was about a person that we represent. And I think what we are attempting to do is to talk about people. There are people who are serving life without the possibility of parole. That doesn't move people. What moves people is the story of the woman with 2 kids who will never touch those kids, will never see those kids, who's spending the rest of her life in an upstate New York prison because she was a drug mule. That's how we're changing the culture. We're changing the culture because we are asserting ourselves and we are taking control of our stories. And that's what we need to do.
Could I just, oh, I'm sorry. Switch the
So
time.
I just wanted to say a word about.
There it is.
Okay. I just wanted to say a word about trials and pleas. Michael talked about trials and the importance of trials. But an important fact for people to know is that, you watch television and Law and Order and, the 10 different Law and Orders and all the crime shows, and you think all these trials are going on, when in reality what's going on in our criminal justice system is guilty pleas. There are not a lot of trials going on. About 95% of all criminal cases are resolved by way of a guilty plea. And, the plea bargaining process has its pluses and its minuses, but there's a lot going on with the plea process that is really wrong. And rather than spend a whole lot of time on it, I would urge everybody to go to the PBS website, pbs.org, and look for the Frontline link. There is a documentary called The Plea, which is just extraordinary. And it's online, you can watch it. Abby actually is featured in it. And there are a lot of stories, like the ones Williams talked about, of people whose lives are affected by that. So we think about trials, but also think about the plea bargaining system, which is just sorely broken with public defenders who have way too many clients, who have to get a plea offer the same day they meet their client and advise their clients the same day to plea, something that I, as a lawyer at the Public Defender Service, never had to do and would think unconscionable, and that actually violates the ethical rules, right? That you're advising a client to take a plea when you haven't investigated the case and you have no idea. This is going on in courts every single day in these United States. And it's unconscionable, but it's going on. And until we change that system, we will come nowhere near justice in our criminal justice system.
If I can, I don't know if this is on anymore. So Obama said awesomely a while back that it's not class warfare, it's math. So don't think that I'm full of bitter envy for the 1%, but it's not really a culture of vengeance, it's just a culture of money. Locking people up is big money. They have trade shows about private prisons and restraint chairs and how to force feed people, and this is all a huge part of the economy. So it's not just that we all suddenly became mean Puritans that wanted to put people in stocks. It's that we figured out that we could commodify suffering and loss and grief. And it's not just people who are, these juveniles who are serving life without parole or people who are on death row, but there are so many people who are just serving lengthy sentences that maybe they have a number and a parole eligibility date, but they're never going to get paroled, and that they're going to die in prison. Abby was telling me this morning that some poor 88-year-old guy just got denied parole because I guess he hasn't learned his lesson yet. But it's a money thing, and at the bottom, I think, of all of this is the fact that greed is the most powerful engine in this country right now.
I just wanted to add on a positive note, I think there are 2 areas in which we're seeing more movement and more of an open mind, even on the part of prosecutors, and that comes in the area of judicial diversion, drug cases where somebody has a documented drug problem, where they're being given an opportunity to go through a drug treatment program in lieu of incarceration, with the understanding that should they fail out of that program, that there will be then some serious consequences to pay. But it's statutory, it's through the court. The prosecutor cannot say no if the person is approved. So there is some movement. We've had success with clients who have gone through judicial diversion. Most recently, we represented Miss Russia, who actually successfully completed judicial diversion. knock on wood. That was last week. We'll see what happens next week. But with respect to mental health, that's, I think, another area where there's been some movement, but I think there could be a considerable amount of additional movement. There's mental health courts that some prosecutors in various counties have instituted. Unfortunately, the prosecutors are the ones who can decide whether or not somebody is approved for mental health court in lieu of going through the typical procedure. And again, it would be similar where there would be mental health treatment. If they successfully complete that, then there would not be incarceration. What we've seen, though, is that is with completely different, like judicial diversion, where at the end of the day, they may wind up with no criminal conviction. They're being asked to first, they must plead guilty. So they have to plead guilty to an indictment and then go through the process, and if they're successful, then that plea is withdrawn, and then they go on with their life and all is good in the world. Unfortunately, if someone isn't a citizen, they can't plead guilty. They cannot allocute to a crime. And if they do so, even at the end of the day, when the case is ultimately dismissed, they can still be deported. And we've had some success with some offices where they will consent to our client not having to allocute, not having to plead guilty, and still go through the process of judicial diversion. And we've had other instances where the DA's office says, too bad, you know, your guy should have thought about his immigration consequences before he committed the crime. And, you know, it can have really devastating consequences. So, you know, there is movement. I think we're moving in a direction. We're just not there yet.
So I want to take 1 minute to ask one more question, and then we can. Oh, I'm sorry, I didn't see that.
This question is mostly for the women at the table. I was wondering if you could talk about some of the obstacles that you might face that your male colleagues might not face in this position, and how you've dealt with those challenges along the years.